Hello, everyone, and welcome to Conn Maciel Carey's 5th webinar in the 2018 Labor and Employment Series. And in this webinar, Dan, Deacon, and I will just be talking about a few of the pressing topics that we see day in and day out from an employment law perspective. Just a few housekeeping notes. Hopefully you'll see there's a small chat function on the bottom left side of your screen. And so you know we are recording today's webinar, and we will make a copy of the slides available to you. For audio quality reasons, we have you on mute, but in that box, feel free to type any questions that you have, and Dan and I will try to respond either immediately when we see them, or if we're in the middle of a topic, sometimes it's just easier to respond at the end, but kind of depends how the questions are coming in. So you know who we are if you haven't heard us speak before. My name is Jordan Schwartz. I'm a partner here in the Labor and Employment Practice Group, and I really do all aspects of advising and litigation in the employer-employee relationship. That ends up being a lot of ADA work, a lot of Title VII work, which is a lot of what I'm going to be talking about today, some wage and hour, Fair Labor Standards Act, the FMLA, and basically it's a split between litigation and counseling employers. And when we counsel employers, it's basically with regard to compliance with all sorts of federal and state laws, you know, including hiring, firing, discipline, investigations, and things of that nature. And along with me is our associate, Dan Deacon.
Hello, everyone. My name is Dan Deacon, and I'm an associate here at Conn Maciel Carey. I've been here close to 3 years now, and I work in both the Workplace Safety Practice Group and the Labor and Employment Group. So I represent employers during inspections and investigations conducted by federal and state OSHA. And on the labor and employment side, I advise and counsel employers with respect to all aspects of the employer-employee relationship, including wage and hour disputes, claims of discrimination, and I also handle the litigation aspects of those topics as well. And I also assist in reviewing and revising employee handbooks and drafting workplace policies and procedures. So with that, I'll turn it back over to Jordan, and he'll go through the agenda, and we'll start the presentation.
Great, thanks, Dan. So for our presentation today, we're going to be talking about similar things we've talked about in the past, but you know, one of the reasons employment law is so fascinating is while there might be the same issues, they change so much from year to year based on the case law, the administration, the kind of tenor of the different agencies. So with that in mind, I'm going to start off and talk about transgender issues in terms of employment law, and that'll probably take nearly half the presentation because that's a fairly complex issue that's somewhat unresolved in the courts as of today. And then Dan will talk about pregnancy discrimination, light duty accommodation, along with pregnancy discrimination. He'll hit ban the box quickly and then talk about social media issues, which is always a fascinating and quickly changing area of the law. So with that being said, I'm going to start right in with transgender issues. And before I talk about what you as employers, what you really need to do from a guidance perspective, it's just a little too complex for me to just give you advice right away. So I need to just take you through some definitions so you know what the correct terminology is. And you're probably not going to remember all this, but at least have it in mind so you can see where the courts are going with these issues and then where you need to go if you have any employee issues where someone who's transitioning comes up to you and asks for an accommodation. So the next few slides are just going to just kind of give background about this. And I'm starting with what is gender identity. And the two definitions that the courts look at when there's ever a discrimination lawsuit based on gender identity is one, they refer to it as a person's perception of having a particular gender. And that perception may or it may not correspond with that individual's birth sex. The other definition that we see is gender identity is one's innermost concept of self, either as male, female, a blend of both, or neither, and how individuals perceive themselves and what they call themselves. I read one study that says there's 700,000 transgender adults in the U.S., although I've read other studies that say that number is severely underreported. So I think it's fairly safe to say there's at least a million transgender adults in the U.S. Currently. Other important terms that you need to know about that courts look at are, one, gender expression. And that's really where Title VII of the Civil Rights Act comes into play. And gender expression is the external appearance of one's gender identity, usually expressed through behavior, clothing, haircut, or voice, and which may or may not conform to socially defined behaviors and characteristics that are typically associated with being either masculine or feminine. And the main Supreme Court case on that, and I'll get to it in a minute, was actually from way back in 1989. So although this is somewhat of a new issue, the background of these issues and these thoughts and how to deal with them from a legal perspective have actually been going on for a while. And then transgender is an umbrella term for people whose gender identity and expression is different from cultural expectations based on the sex they were assigned at birth. Note, and I have it highlighted here, being transgender does not imply any specific sexual orientation. Therefore, transgender people may identify as straight, gay, lesbian, or bisexual. And that's important because right now the courts have treated transgender individuals differently than discrimination cases based on sexual orientation. So you can't just group those two together. And then the last definition slide I have here is gender transition, which is, of course, the process by which some people strive to more closely align their internal knowledge of gender with its outward appearance. But the transition for some people might just be a social transition where they might begin dressing differently, using different names and pronouns, or be socially recognized as another gender. Others might undergo a physical transition, but a physical transition isn't always necessary to request an accommodation or bring a lawsuit. And then gender dysphoria, which is what most employees bring lawsuits as a result of, is a clinically significant distress that's caused when a person's assigned birth gender is not the same as the one in which they identify. So if you deny an employee who's transitioning, if you deny that employee access to their preferred restroom, they would likely sue stating that they have gender dysphoria and you may have contributed to furthering that. So as an employer, what are the issues that are likely going to be coming into the forefront if you have these types of situations? And of course, with transitioning employees, as I just mentioned, you have restroom protocols. I know a number of you on this call are in the hospitality industry or run fitness centers and fitness clubs. Of course, then there's also the extra layer of locker room protocols and procedures, and there's a bunch of case law coming out on that, and I'm going to talk about a few of those cases. Certainly dress codes, name identification, what someone's preferred name is, discrimination and harassment based on an employer not respecting the name identification, dress codes, or restroom protocols. And I'm going to give you some best practices and policies of what to do in these types of situations. Generally, as I mentioned, there was a lawsuit way back in 1989. It was called Price Waterhouse versus Hopkins. And in that case, a female senior manager in accounting for, at Pricewaterhouse, she was denied partnership, and the reason given was because she was considered macho, and she was told she could improve her chances for partnership if she could take a course at charm school, walk more femininely, wear makeup, have her hair styled. And what happened was the Supreme Court found that she was discriminated against because of her sex, and that was a form of sex stereotyping. So since then, Title VII, the general anti-discrimination statute for employment, bans sex discrimination, which includes employees treated differently for failing to conform to sexual stereotypes. Since that Pricewaterhouse case, there have been numerous cases over the years, both from a male and female perspective, where the employee has been successful for saying that he or she was discriminated against for failing to conform to sexual stereotype. And now, gender, which includes gender identity, self-image, appearance, behavior, or expression, the EEOC has found that Title VII now prohibits discrimination based on gender identity, which is why I wanted to explain to you what gender identity meant. It's interesting because the second slide here is that the U.S. Attorney General previously issued a memo stating that Title VII specifically banned discrimination because an employee is transitioning or has transitioned. That memorandum has now been rescinded by the current administration. But that doesn't mean that's no longer the law, because the courts are still finding that that's the law, and the EEOC is still advocating that that is the law. So it's an interesting kind of dichotomy right now in our legal/judicial/political climate. So and I'll talk specifically about some of the cases in a minute, but certainly you don't want to do anything intentionally to make an individual who's transitioning at your workforce feel bad. So if they express their desire to be called a different name or be called a different gender pronoun that corresponds to their self-identification, unless circumstances dictate otherwise, I would advise you that you should adhere to the individual's request. By intentionally and persistently failing to do so, you could be setting yourself up for a harassment claim. Some employers have told me they want to wait until a physical transformation is complete, and I understand that, but there's really no basis for that under the law. And courts have found this to be intentional and unlawful harassment. Certainly denying equal access to a restroom corresponding to an employee's gender identity can also be harassment. I understand that is a very tricky issue, and other aspects of that issue come into play, but just know that there is a chance that not granting an individual his or her preferred restroom could result in a harassment charge. As I said, many federal agencies have interpreted prohibitions in Title VII to include transgender discrimination, and now several of those agencies have rescinded. So there's really a split right now under federal law. And under state law, essentially there's a split too. Many of you probably remember the big issues the past few years in North Carolina and in Texas relating to bathroom access. But on the other hand, many states have passed their own laws permitting transgender employees to use restrooms consistent with their gender identity. And I just have a few right here. Colorado and Delaware have these types of laws. Washington, D.C. does. Also Iowa, Vermont, and Washington. And they all really talk about I'm not going to get into the details now, but about using restrooms corresponding to self-identification. Now, all of that being said, let me just talk for a minute now, because it all gets kind of interrelated here, to sexual orientation. Up until last year, no court, at least no federal appeals court, had ever held that sexual orientation was protected under the law as a form of sex discrimination. But that changed about a year ago when the Seventh Circuit, the court that oversees Indiana, Illinois, and Wisconsin, they were the first court that held that Title VII actually prohibits discrimination based on sexual orientation. Just a month earlier than that, the 11th Circuit, which covers Louisiana and Florida, held that Title VII does not prohibit discrimination based on sexual orientation. So, as you can imagine, this causes a significant, confusion for employers all across the country. And then that dovetails with the newest case on this issue about 2 or 3 months ago in New York, the Second Circuit, where a skydiver instructor, he claimed his employer fired him because of his sexual orientation. And originally, the Second Circuit held that, under Title VII, sexual orientation is not protected, so this individual does not have a claim. It then, however, reversed itself and said that sexual orientation indeed is discrimination because of sex under Title VII. So now you have, with the Seventh and Second Circuit aligning, you have, if you're an employer in New York, in Connecticut, in Vermont, in Indiana, in Illinois, or Wisconsin, you cannot take any adverse action whatsoever for because of an individual's sexual orientation. There is not that protection in Georgia, Alabama, or Florida. And basically everywhere else, I can't really tell you. It's kind of a roll of a dice. I would argue that you don't want to be taking adverse employment actions simply because of sexual orientation, but if you are in one of those states where it's not prohibited, it's a little less risky. I can't imagine that the Supreme Court will not take up this issue sometime relatively soon, so hopefully we will get an answer on this. It really is interesting, though. In this Second Circuit case, the EEOC actually submitted an amicus brief because the Second Circuit asked it to about what it thought about sexual orientation, and the EEOC argued that sexual orientation falls squarely within the protections afforded by Title VII. But then the Department of Justice, without being asked, submitted another amicus brief and actually completely opposed what the EEOC said. So typically, whereas the federal agencies were all on the same page, it is really interesting now that they are all arguing against each other. So I just wanted to throw that out there, even in this discussion of transgender issues. The OSHA, also another federal agency, they are in the side of the EEOC. They have recently issued guidance about restroom access, although, as you can imagine, OSHA looks at it more from a workplace safety point of view. And the guidance from OSHA reiterates that there are numerous adverse health risks from restrictions to bathroom access. As a result, OSHA has instructed employers that requiring transgender employees to use a bathroom inconsistent with their gender identity may make them feel unsafe, or could even make them otherwise avoid using restrooms entirely at work, which would, of course, cause them potentially bodily harm. So while this isn't necessarily binding as it would be from a court, it is instructive, and it is something you want to think about when you're implementing your policies and practices. And those practices that OSHA recommends have a written policy ensuring that all employees have prompt access to appropriate sanitary facilities, perhaps provide additional bathroom options such as single occupancy, unisex toilet facilities, or like many states and recommend, multiple occupant gender neutral restrooms with lockable single occupant stalls. What you shouldn't do, and OSHA talks about it specifically, is do not ask employees for medical or legal records of gender identification in order for them to get access to a specific toilet facility. And, you know, we want to get away from the separate but equal thought process, so do not require transgender workers to use a segregated bathroom. If there's a restriction on access to a toilet, you know, either in locker rooms or requiring employees to ask permission, you know, if it's a work necessity, the restriction still must be reasonable and may not cause extended delays because, and this is kind of where OSHA's looking at it from a workplace safety. I'm looking at it from an employment lawyer. The workplace safety issues could merge into an ADA issue, which you already may be faced with a Title VII issue. You really don't want to be faced with an ADA issue. But if you deny an individual bathroom access and they have some sort of condition that requires them to use the bathroom, you know, whether it be pregnancy, which Dan will talk about in a few minutes, or other bladder control issues or prostate issues, then you could be setting yourself up for an ADA claim, which is just a place where you do not want to be. Just to talk a little bit about, you know, as I told you earlier, there's been a bunch of cases talking about these types of situations. And I'm not going to get too much into the details, but just kind of to outline these cases. EEOC sued on behalf of a transgender employee against Barnes & Noble, who that individual was allegedly denied access to the woman's bathroom and subjected to a hostile work environment. I know her manager said she worked in a neighborhood store and should think of the children as a result of the way he didn't appreciate her dressing. And the manager also said that, you know, this individual would not be called by her new name, and she should not discuss her transition in the workplace, and she cannot use the women's restroom. And, of course, that type of conduct violates Title VII, and Barnes & Noble ended up settling that claim for a significant amount. Recently, a motion to dismiss filed by the employer was denied, and this is extremely interesting because, you know, it's in Kentucky, a place that's not thought to be, you know, the liberal forefront when we're talking about transgender issues. But, and this case was interesting because it was more of an FMLA ADA case where he was denied medical leave. And then after he revealed his transgender identity, he was fired. But he had already been bringing a claim based on his failure to be provided leave under the ADA and FMLA, and saying he was treated differently because of his transgender. So in addition to being, you know, just fired, denying leave or treating an individual differently, perhaps because of the transition, is, you know, basically a surefire way to get yourself hit with a Title VII lawsuit. This is another case that actually claimed that his union discriminated against him and retaliated against him for failing, you know, once they found out about the transition status. And you know, that's a very interesting claim. but there's a few different claims against fitness clubs right now where they talk about locker room policies. And if any of you have locker room issues, it's probably needs to be a more in-depth discussion than we have time for here. But these cases have almost uniformly taken the individual side. Either it's an employee or, in these few cases, it's a member of the fitness center who say that they should have the right to use the locker room that they see fit. And the question I always get asked is, well, what about other individuals who don't want these individuals to use the locker room? But these, at least currently, the courts haven't really been as concerned about those individuals and are more concerned about the transitioning employee and have ruled on the side of the employees. And this Planet Fitness case was actually a case brought by a member who was not transgender, but alleging harassment based on Planet Fitness's transgender inclusive policy. And the court ruled on behalf of Planet Fitness in that case. For Crunch Fitness, the lawsuit was actually brought by a transgender woman who she actually told her employer that she was transitioning. They said, you know what, let's wait till it's actually a physical transformation. In the interim, she kept on getting harassed in the male locker room, and she ended up bringing suit as a result of that harassment. Interestingly, there's also, I just wrote this quickly, this doesn't apply as much because this is out of out of Canada, but there's even a complaint in Canada about someone refusing spa refusing to treat someone because of transgender related issues. So I just wanted to include that real quickly. But what I want to get to last before I hand this over to Dan is really the question that many of you may have been waiting for here with all the legal background there is, what should the action steps be? What if someone comes up to you, one of your employees, and tells you that they are transitioning? Or what if you notice that an employee is transitioning? What should then happen? And what I recommend is that you really need an initial meeting with the employee. And it's got to be with a representative of management, possibly the HR person, maybe even the direct supervisor. It really depends on the specific situation. But you need some sort of roadmap about both what do the employee and what does management expect throughout the transition process. Assuming the supervisor isn't in that meeting, then the management will need to meet with the supervisor to educate the supervisor about the process and review company policy and procedures. And again, then there may be a joint meeting with both the employee and the supervisor to discuss the transition plan and any questions or concerns. The next step, and I have a question mark here because this really depends on your work culture, is whether you inform coworkers about the transition. And it really a lot of times depends on if the employee is comfortable with this. If you get the sign-off from the transitioning employee, you may want to provide other coworkers with basic information about the employee's plans. And in that case, then you can, with these other employees, discuss policies, discuss expected behavior, address individual concerns if there are any, and create an atmosphere where employees feel comfortable asking whatever questions they need to ask. Of course, at the end of the day, as your counsel and as company representatives, I am trying to figure out the best way for you to minimize potential liability. And to do that, it would make sense for you to amend your non-discrimination and anti-harassment policies so that they include gender identity and sexual orientation if applicable based on where you are, and conformity with gender-based preferences, expectations, and stereotypes. You may, depending on your industry, want to even consider changing gender-based dress codes. And you also want to establish gender transition protocols. As I mentioned earlier, you want to make sure there's clear expectations for management, both management and the transitioning employee. And something also that you might not think about, what about personnel records? If the employee actually does go through with the change, you'll need a procedure so the personnel records can be changed from he to she. Of course, as with all these types of issues, you want to make sure to educate and train your workforce in general about company policies and transgender issues. You could do this along with harassment training sometimes. Depending on your industry, if you have locker rooms, you want to update your restroom and your locker room access policies with some of the issues we've discussed. And as I mentioned a few times, it's really smart to use preferred names and gender pronouns. There's always, you read every day about supervisors who resist doing this, but you really have to make sure you don't have supervisors resist doing that, because that's just such an easy way for a harassment lawsuit to occur. And with that being said, that's all I have for a quick summary of the transgender issues, and now I'll turn it over to Dan to talk about the remaining issues.
Thanks, Jordan, and good afternoon, everyone. I'm going to be talking first about pregnancy discrimination. This is another hot topic in the law that can be particularly tricky for employers, particularly as it relates to accommodations of a pregnant employee. So we're just going to start out first with pregnancy and the ADA and a little bit of background of how those interrelate. So pregnancy discrimination is predominantly controlled by the Pregnancy Discrimination Act, the PDA, and that's a federal statute that protects pregnant workers and forbids employment discrimination in any aspect of employment. So that includes hiring, firing, pay, training, promotions, benefits, such as health insurance, and any other term or condition of employment. And that's based on someone being pregnant or childbirth or a related medical condition that's related to that pregnancy or childbirth. The PDA may also require covered employers to make certain job-related modifications for pregnant employees. Specifically, the law requires employers to treat a pregnant employee who is temporarily unable to perform or is limited in performing the functions of their job because of pregnancy, childbirth, or a related medical condition in the same manner as it treats other employees who are similar in their ability or inability to work. So in addition to the Pregnancy Discrimination Act, the Americans with Disabilities Act, the ADA, comes into play, and that may be relevant if an accommodation related to pregnancy or childbirth is requested. The ADA requires employers to provide reasonable accommodations to employees with disabilities, so long as doing so does not impose an undue hardship on the employer, on the business. So although pregnancy alone, pregnancy itself is not a disability under the ADA, many pregnancy-related conditions are disabilities that an employer may have to accommodate under the ADA. So it's important to keep that in the back of your mind as well if an employee that is pregnant comes to you seeking an accommodation. So under the PDA, an employer that allows temporarily disabled employees to take disability leave or leave without pay, they need to allow an employee who's temporarily disabled due to pregnancy to do the same. Essentially, under the PDA, an employer is responsible for making those job-related modifications or accommodations for pregnant workers when the employer does so for other employees who are similarly situated, similarly limited in their ability to perform their job duties. For example, if an employer with a policy of accommodating most non-pregnant employees with lifting limitations would be required, you'd also need to accommodate a pregnant employee with those lifting limitations. So ultimately, you can't single out pregnancy-related conditions for special procedures or policies to determine whether they have the ability to work. If an employer requires its employees to submit a doctor's statement, however, concerning their ability to work before granting leave or paying some type of benefits, the employer can require employees affected by a pregnancy-related condition to submit such documentation. So ultimately, an employer is not required to treat a pregnant employee better than a non-pregnant employee, but a pregnant employee cannot be treated any worse than someone similarly situated. Skip ahead one there. So one of the most common questions that we get from clients related to pregnant workers is whether an employer is required to provide light duty. And as explained in the previous slides there, an employer is required to provide light duty to a pregnant employee whose condition does not constitute a disability under the ADA, if the light duty work would be provided to another employee with a similar ability or inability to perform that work. So, for example, if the employer's provided light duty work to an employee complaining of a lower back problem, it can't deny light duty work to a pregnant employee who also complains about that lower back pain due to her pregnancy. In the context of the ADA, light duty can be an appropriate, reasonable accommodation depending on the employee's specific pregnancy or childbirth-related condition. If an employee has pregnancy-related carpal tunnel syndrome, for instance, light duty, that may be sufficient to accommodate her. So the seminal case on pregnancy discrimination, and many of you may already know this, is a case from the U.S. Supreme Court dating back to 2015, and it's called Young versus UPS. In that case, the UPS driver claimed that she was illegally discriminated against when she was denied a workplace accommodation that was made available to other employees with similar physical restrictions. Specifically, during her pregnancy, her doctors advised her not to lift more than 20 pounds while she was at work. And UPS's employee policy at the time required its employees to be able to lift up to 70 pounds. And as many employers do, UPS limited its light duty positions to specific groups of employees, those injured on the job, those with disability covered under the ADA, or those who lost their DOT certification. Since Young did not fall within one of those categories, she took unpaid leave, an unpaid leave of absence during her pregnancy, and as a result lost her medical coverage. So she sued UPS and claimed that she had been the victim of gender and disability-based discrimination under the Pregnancy Discrimination Act and the ADA. UPS argued that Young could not show that its decision was based on her pregnancy or that she was treated differently than other similarly situated coworkers outside of the three categories of employees eligible for light duty work. The Supreme Court held that a pregnant employee can establish a prima facie case of disparate treatment by showing that, one, she belongs to a protected class, two, she sought an accommodation, three, the employer did not accommodate her, and four, the employer accommodated others similar in their ability or inability to work. The court ultimately determined that Young did establish her prima facie case, but sent that back to the Fourth Circuit to determine whether the justification provided by UPS, the legitimate non-discriminatory reason that was put forward for refusing to provide accommodation, was sufficient to meet its burden. And at that stage, UPS and Young ultimately settled the case. So the Fourth Circuit didn't have a chance to consider the issue on remand. So we have the general framework for discrimination under the Pregnancy Discrimination Act, but we haven't seen how that is technically applied. Another big case that is ongoing was filed last spring in May 2017, and that was a case filed by a number of workers at Walmart, and the suit points to a change to Walmart's disability accommodation policy that was in place between March 2013 and March 2014. The complaint claims that Walmart's policy limited modifications for pregnant employees to those that would be easily achievable and which will have no negative impact on the business. But non-pregnant employees were entitled to reasonable accommodations so long as the change would not create an undue hardship for the company. So there was two different standards being applied there for pregnant employees and then non-pregnant employees. So one of the employees specifically alleged that during that time period, her managers refused to request to follow her doctor's advice and avoid climbing ladders and lifting heavy objects, and they instead placed her on unpaid leave. When the employee returned to work, she wasn't reinstated to her old position in the Walmart pharmacy, but was instead assigned to some other lower-paying positions. And it's worth noting that this case was filed as a class action. The class size isn't known at this point. Walmart did file a motion to dismiss, and that was recently denied. I think it was just last month in April. But this case demonstrates the significant impact that these claims could have on employers if it proceeds to litigation. Walmart is a large company, and I imagine there would be a substantial number of people that would be included in this class. So the next few slides here provide some best practices for employers to mitigate risks and avoid these claims. So to help avoid these pregnancy discrimination claims, employers should review accommodation leave, scheduling, and attendance policies to make sure pregnant workers are not disfavored and are treated in the same manner as similarly limited employees. If there are workplace policies that limit employee flexible use of certain benefits, such as leave or alternative scheduling, make sure that those limitations are based on a business necessity. Finally, if you have a parental leave policy, make sure it's applied in the same manner to both men and women seeking to use the policy. Where feasible, we recommend temporary reassignment of job duties if an employee is unable to perform due to pregnancy or a pregnancy-related condition, both to address the needs of the employee and limit the possibility of an employee claiming discriminatory treatment. So if a pregnant employee will be taking leave, consider consulting with the employee in advance, again, to address both the employee's needs as well as to determine the needs of the business. The more proactive you are about that, the more time the business will have to find cover of those job functions, and it will lessen the impact on the business once you get to a point where leave needs to be taken. So finally, the last bullet here, you should also ensure that employees on pregnancy leave have access to all the benefits and opportunities made available to other employees, and that includes training. This is the last slide here on some of the best practices to avoid these pregnancy discrimination claims. First here, where a pregnancy-related condition meets the definition of a disability covered by the ADA, you want to have a process in place to quickly consider and grant reasonable accommodation requests made by that employee. You also want to state explicitly in any written policies or procedures that you have the reasonable accommodations that may be available to individuals with temporary impairments, including those related to pregnancy. And finally, you want to train your supervisors on how to respond to a pregnant employee's need for an accommodation and the use of the interactive process. A manager shouldn't change a pregnant employee's job functions or duties or place her on leave based on a perception that the employee is disabled or impaired because of her pregnancy. Employers can get into a lot of trouble if they make decisions like that on behalf of pregnant employees. That's a no-no. So in sum, employers should carefully review their policies, especially as to medical issues, leave time, and light duty, which could impact a number of different federal laws here, the Pregnancy Discrimination Act, Family Medical Leave Act, and the Americans with Disabilities Act. There's a multi-level analysis that may need to be done based on these different laws that are at play or may be at play. A facially neutral policy may have a disparate impact on pregnant employees, and you need to take that into consideration when reviewing those policies. Finally, employers should make sure that they check each jurisdiction in which employees are located to see if there's any additional state or local laws or regulations on these issues. It's essential to not only understand those federal requirements, the ones that we're talking about here today, that relate to pregnancy, but again, there's additional state or local safeguards for pregnant women. For example, some states have their own laws regarding parental leave and pregnancy accommodation, and in any policy or procedure must align with both federal and state requirements. So these next few slides are on Ban the Box, and I'm just going to cover them really, really quickly since we're coming up on time here, and I'd like to get to the social media piece of the presentation. But this is another big area of anti-discrimination law that we're seeing a lot of now, and that's, of course, the Ban the Box laws. And generally, the Ban the Box laws eliminate questions about criminal convictions on job applications and push such inquiries until later in the process. And I think the main point that I want to make on these slides, I'm going to condense everything into just a few short bullets here. But you shouldn't be considering arrests as a factor in making an employment decision, and you need to be extremely careful when making an employment decision based on a criminal conviction. And there's three factors typically related to criminal convictions in analyzing whether a conviction should impact an employment decision. And that's 1, the nature and gravity of the offense, 2, the time that's passed since the offense, and 3, the nature of the job held or sought. And that third factor is especially important as it relates to the EEOC guidance that was issued on these issues in about, I think it was 2012. According to the EEOC guidance, there must be a relationship between the conviction and the job position for it to be pertinent in consideration of the employee's application for hire. And also, I just want to be clear here that inquiries into criminal convictions are not categorically prohibited. You are allowed to inquire into an applicant's criminal history. Typically, that's later in the process, notably after a conditional offer of employment is made. And there's various different state and local laws that govern the Ban the Box laws and how that's applied. So be aware of the state and local jurisdiction that you're in and the applicable laws as they relate to Ban the Box. And finally, this last slide here before we can get into the NLRB and social media issues is just some action items that you're going to want to take in making sure that you're complying with those ban-the-box laws. You also, in addition to reviewing your state and local jurisdiction laws, you want to conduct individual assessments of your applicants, including evaluating the relevance of any prior conviction to the position, as I stated at the beginning. You also want to document any legitimate business reason for not hiring an applicant based on their criminal history and the information you considered in making that determination. And finally, the last bullet here, it's important you understand and comply with other relevant laws, notably the Fair Credit Reporting Act. There's been a spike in FCRA litigation recently, and it's an easy target for class action litigators. So if you do run background checks, be sure that you know what the FCRA requires. So now we'll move on to a pretty interesting topic, and it looks like we only have about 10 minutes to cover this topic, but I'll do my best to get all the information out in that time frame. So this is another big area of the law that is changing. Every couple months it seems there's some new guidance or a new decision that's changing, or the composition of the board itself. But first, we're going to start out with what is social media. And as you all know, those are things like Facebook, Twitter, blogs, YouTube, Snapchat, Instagram. Social media activities include, posting, viewing, utilizing an internet-based program that can be shared with others. So Section 7 of the National Labor Relations Act is a key provision here, and that affords all employees, not just union members, the right to self-organization, to form, join, or assist labor organizations to bargain collectively through representatives of their own choosing, and the key part that we're going to focus on here, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So any employer policy or practice that restricts such rights under Section 7 is vulnerable to a charge of unfair labor practices. And under the Obama administration, the board issued several decisions finding employer policies related to social media as overbroad and violative of Section 7. And as you may be aware, some of those cases have already come up, and the law is beginning to change. So now we'll talk quickly about the extent employers can, regulate social media use of its employees or act on what is considered unprotected behavior or speech. So employees have the right to use social media to engage in concerted activities. And the NLRB has traditionally found unlawful restrictions on the right to engage in social media activities in two categories. And those are 1, discipline or discharge of an employee, and 2, overbroad social media policies. And activities that typically aren't protected and can be used and in employer social media policy include the following that you see on the screen there: personal issues that don't impact others, threats of violence, harassment, discrimination, retaliation, and unlawful use of company logos and trademarks. So the NLRB in recent years has found several social media policies to be vague and overbroad. And you see on the screen here there's 6 examples, including policies prohibiting rude or offensive comments, or accurate, and policies requiring that statements on social media be accurate and not misleading, or requiring employees to report inappropriate social media content. And all of those types of policies under the Obama administration were found to be violative of employees' Section 7 rights. And one of the notable cases that I'm going to cover on the next slide here is the Chipotle case. But the social media policies under the Trump administration appear to be changing. On December 1st, 2017, the NLRB General Counsel, Peter Robb, issued his first General Counsel memorandum. And in there he indicated that his agenda would not support many of the Obama-era initiatives. In fact, he called into question 15 significant legal issues that would now be subject to what he termed as alternative analysis. And included in one of those 15 significant legal issues was social media postings. So we'll see in the future what that has in store. Again, it was 8 years under the Obama administration and these policies, and the status of the law at the NLRB isn't going to change overnight, but it is changing as we speak. But going back to 2014, the Chipotle case was a pretty seminal case on social media issues. The contested language there, in quotes, you can read it for yourself. Chipotle's warning to not spread confidential information on social media was problematic, and it was an undefined term that was ruled to be vague, and the NLRB said an employee could easily interpret that policy to bar protected conduct, and the savings clause that Chipotle had at the end, which was basically, this code does not restrict any activity that is protected or restricted by the National Labor Relations Act. That was insufficient to cure the unlawfulness of the foregoing provisions that you see on the screen there. Another interesting case that the NLRB General Counsel specifically highlighted in his first General Counsel memorandum as being problematic is this Pier 60 case, and that was a Second Circuit decision that enforced the NLRB's decision ordering a catering company to rehire a worker after it fired him for a social media rant, where he called his boss a number of expletives that I will not be sharing with you on the presentation here today. But if you'd like to know specifically what he said, check out this case because it's an interesting one. So although the comments were inappropriate, very inappropriate, the Second Circuit found that his close proximity to a union election date and entreaty to colleagues to vote yes brought the remarks within the NLRA's protections. And basically it was a rant about his boss for 3-4 lines, and then at the end it said vote yes for the union. That was it. But what this case teaches employers is to consider the following before firing an employee for messages that they put on social media. Take into consideration the context of the comment. Again, this was around a union election, and he brought up the union election in the message. You also want to review your policy and workplace culture and speak with an attorney and take your time in handling these issues. There's no reason to rush them, and this is something that you don't want to mess up. After all, the catering company did have to rehire the worker. Another interesting case back in June 2017, about a year ago, is Whole Foods versus NLRB. Whole Foods instituted a no recording policy to encourage open communication and free exchange of ideas. And this is a Second Circuit opinion again. It affirmed the NLRB's order finding the employer's rules prohibiting recording of company meetings or conversations in the workplace violated the National Labor Relations Act. The Act protects recording if employees are acting in concert for mutual aid or protection and no overriding employer interests exist. The court noted that an employer's interest in maintaining no recording policies can be accommodated simply by narrowing the policy scope. So not every no recording policy that places limits on recording audio or video in the workplace violates the Act. And that's something to keep in mind. Tailor that policy accordingly. And finally, this is the last slide in the presentation. So we are coming just about up to our time here, and I'll get through this. But this is an important case that is very recent. It was back in December 2017, and it highlights the shifting nature of the board and the direction that it's going, especially considering its new makeup with the Trump appointees. So this was the Boeing company. Again, the decision was issued back in December 2017, and the board's new 3-member majority established a new standard for evaluating the validity of employer rules, policies, and handbook provisions under the Act. Under the new standard, the board no longer will focus solely on whether the employees would reasonably construe a rule to restrict rights under the Act to determine if the rule is unlawful. Rather, when reviewing a facially neutral rule that, when reasonably interpreted, would potentially interfere with the exercise of employee rights, the board's going to evaluate, 1, the nature and extent of the potential impact on those rights, and 2, legitimate justifications associated with the rule. So when legitimate justifications outweigh a rule's potential impact on protected rights, it will be found lawful. Additionally, to provide clarity and predictability in this area, the board delineated 3 categories into which rules would be placed in future cases based on this balancing test. And that's 1, lawful, 2, unlawful policies, or 3, policies subject to individualized scrutiny on a case-by-case basis. In this case, the board found that the employer's workplace no-camera rule was lawful, and that reversed prior cases in which similar rules were invalidated or found unlawful. It further found that in the future, no-camera rules will be treated categorically as lawful. So what this decision really does is it radically changes the way the board's going to evaluate employer rules, including rules pertaining to conduct in and out of the workplace, such as those involving social media. So although this case was not specifically about social media, this is the framework under which the social media policies will be scrutinized under now. So by balancing considerations favoring maintenance of rules, workplace rules, this new standard is definitely going to expand the scope and type of rules that the board will find lawful, and it's going to improve an employer's ability to tailor rules to suit their needs. With that being said, we're a couple minutes over the 2 o'clock end time here, but we appreciate you for sticking with us through the presentation. If you guys have any questions, please feel free to reach out to me or Jordan. Our contact information is at the end. And please feel free to check out our blogs. We're constantly posting new and exciting topics and news on employment law issues and OSHA issues. So if you have any questions, again, feel free to type them in the chat function or reach out to Jordan. All right.
Great. Thank you very much. We appreciate your attendance.